Zehnder Limited.
Mrs. Rick.
Good morning, my lady. My lady, before I return to the roadmap that I handed up yesterday, and I think I'd come to my second proposition, perhaps I can just deal with one matter of housekeeping. I indicated to my Lord Wilson yesterday that I would hand up a copy of Camelling Restrictive Covenants under Common and Competition Law 4th edition, the 2004 edition, and let me just do that now. And as I do that, I'll perhaps just take you to the relevant part. The non-competition clause in that extract appears on the last page, page 448 of the internal pagination. It's clause 11, headed non-competition. I won't go through it, save to note in the middle of that clause, it provides effectively for a specified carve-out to cover a small shareholding.
Thank you.
When you come to look at it, you'll note also on overleaf something said about severance that sets out the position as at the date again of that book. And then finally on that, if I may, I was going to note that whilst we say the position is clear as at 2004, as the authorities note, best practice for any employer is to update the covenants from time to time. So in fact, it would be no answer to say in 2017, oh, well, the problem is when we entered into this contract 13 years ago, the law was slightly different because best practice would have been to update it from time to time, particularly in circumstances where, as you will have seen on the agreed facts, Ms. Tillman was promoted. So that's all I say by way of housekeeping. It takes me then to the second of the propositions on my roadmap, namely that if the restraint of trade doctrine applies, the non-compete clause must be justified as being reasonable, the burden being on Egon Zehnder as the employer. The law closely scrutinises restraints in employment contracts for policy reasons. Egon Zehnder accepts that if this clause prevents Ms. Tillman holding shares in a competitor, it is not justified. I'm not going to spend lots of time on this point. We include it as a logical step in the argument. We don't understand it to be an issue. As Mr. Laddie explained yesterday, he accepts on his case he has no legitimate interest in prohibiting a shareholding, large or small, as he puts it, in a competitor. And no attempt has been made to justify the clause by way of evidence. So that's a very short issue. There's perhaps a couple of points of law that are worth highlighting under it, particularly in the light of my Lady Hale's question yesterday about the extent to which there is any difference between vendor-purchaser agreements and employment agreements. And in this context, perhaps I could just take you to a couple of the authorities. First, the Office Angels case, which is page 1910, and in the hard copy that's volume 4, tab 62. And it's paragraphs, so we don't need to look, I think, for these purposes at the facts of Office Angels. It's really the statement of principle set out by the Court of Appeal in the judgment of Sir Christopher Slade, as he then was, which comes at paragraphs 21 onwards. And the distinction between a vendor-purchaser covenant and an employment covenant is drawn attention to at point 2, paragraph 22. I certainly shan't read it.
But could you give us a page reference again?
Of course, my lady. It's 1910.
What you want us to collect from this?
That the law looks slightly differently at vendor-purchaser agreements, restraints of trade, than it does to master-servant, as it describes them, restraints of trade. Because where you have a vendor-purchaser arrangement, you have a sale of goodwill, and broadly the law takes the view that commercial parties can protect their own interests, whereas an employee is in a slightly different position. And it's a sentiment that's reflected throughout the authorities. For example, my lord, if one were to look in Atwood, the page for that is 799. That will be a core authority. So in the hard copies, Atwood is file 1, tab 2. And if you just look at 799, as I say, of Atwood, at the top of that page, about 10 lines in consequence, it must, I think, be recognised in all courts that there is every difference in the matter of its validity between a covenant as we find here embodied in a contract of service and the same covenant when found in an agreement for the sale of goodwill. So really the point is when it comes to justification, and that's why I deal with it under the head of justification, the law scrutinises less closely, unsurprisingly, commercial restraints as compared with employment restraints. And I'll...
You've justified it as being a case where the parties are dealing at arm's length, but of course an employer could find himself dealing with a very powerful trade union. Isn't the real justification the fact that the vendor and purchaser covenant, non-compete covenant, is to protect a right of property, namely the goodwill that's being sold?
My lady, I would respectfully submit, first, my lady is plainly right, and the authorities do speak of it protecting goodwill. That is undoubtedly right. We would say also that the fact that in an employment contract, what one often sees is a contract which is not moulded by competition, where the employer really is drafting the terms, that's another factor here. But my lady, I certainly accept, and it certainly is reflected in the authorities, that there is every difference between a vendor-purchaser arrangement where there is a sale of goodwill. And if one thinks of the Nordenfeld case, and what comes through from that, as my lady knows, is that the court is very concerned to say a man cannot sell his business for value unless he gives the purchaser that sort of protection. So I completely accept my lady's point. And again, just really for the sake of completeness, I'm not going to turn all of these references up, but if one were to look at the Mason case, Lord Haldane, and the reference is, for your notes, MS 1033, Lord Haldane makes a similar point about employment contracts and says this: in the present class of case, considerations of public policy come in and make it necessary for the court to scrutinise agreements like the one before your lordships jealously. The practice of putting into these agreements anything that is favourable to the employer is one the courts have to check, and judges...
Well, where do we find that quote?
I'm so sorry, that quote is...
You've not given us the page reference to the quote.
I'm so sorry, the page reference, I hope, is 1043.
4-3.
4-3, thank you. You said
Maybe that I
3-3.
misspoke, I
Well,
apologise.
3-3 is where it begins, but...
Yeah.
Yes.
And where are we looking?
And if you look, my lord, in the middle of that page, the paragraph begins the reported cases, but then halfway through that paragraph, the passage begins, it's no doubt as a general rule wise to leave adult persons, and thereafter. And as I've opened this now, whilst we're in Mason, it's worth probably noting at page 1051 what Lord Moulton says. 1051, Lord Moulton's speech begins halfway down the page. And the question, as he frames it in master and servant terms, is, are the restrictions which the covenant imposes upon the freedom of action of the servant after he's left the service of the master greater than are reasonably necessary for the protection of the master in his business? A slightly different question, as my lady, Lady Arden says, to the question, is it necessary to protect goodwill?
But if one looks at the explanation by Lord Justice Slade in the Office Angels case, the sort of things which a non-compete is in fact protecting in an employment case are really part of what makes up the goodwill, are they not? They're the customer connection, the skills of the trade secrets, the things that make the business work.
My Lord, what I would say is this: if one looks at the commercial cases and what goodwill means in the context of the commercial cases, the goodwill is, they normally focus on a sale of goodwill. That is to say, that the purchaser is buying the goodwill. Now, I accept as a matter of common parlance what is that goodwill made up of, but for the customer relations, the confidential information, and the like. But the cases, I would respectfully admit, don't analyse it in those terms. So the employer cases, one tends to look at the legitimate business interest of the employer as confidential information, employment relations, and the like, and treat those as not being quite the same as goodwill, because there's no payment in an employment case. I suppose the difference is this: if you sell your business, you're then paid in respect of the goodwill.
Yes.
And that is, it doesn't perhaps matter for the purposes of this appeal, but that is a distinction I would respectfully submit that the cases do draw. And I'm certainly not going to turn this one up, but the distinction is also drawn to the extent that one wants to look at the Commonwealth authorities in the Canadian Supreme Court case of Chaffron, and the page reference, as I say, I won't pick it up now, we'll perhaps look at it when we look at Chaffron, is 2412 to 2413 at paragraphs 21 to 22. So that's what I say under Proposition 2, and I turn now, if I may, to Proposition 3, which is under the heading Construction. And Proposition 3 is that the maxim of saving the document applies only where there is genuine ambiguity, just as a covenant which is framed too widely will not be whittled down. So too, we say, as a matter of policy, the court should not too urgently strive to use its ingenuity to save by construction a covenant that is too wide on its face. Now, Mr. Laddie told the court yesterday that his argument, and I quote, creates sufficient ambiguity. And he says that is all he needs, again, quote, to save the document. Now, we respectfully submit that what's going on here is that Egon Zehnder, in this case, is manufacturing an ambiguity. And unsurprisingly, that approach is deprecated in the authorities. And one can see that from, for example, the Mission Trust Board case, reference 2066, please, which is a reference to the first page. It's a decision of the Privy Council. All I'll say about the facts is it concerned the construction of a lease and a rent payment clause. That doesn't matter, I think, for our purposes. And if I ask you to turn, please, to 2070, the third of the way down, one has the analysis. And what's said by the Privy Council is this: various rules, it's 2070, various rules may be invoked to insist interpretation in the event that there is an ambiguity. But it is not the function of the court when construing a document to search for ambiguity, nor should the rules which exist to resolve ambiguities be invoked in order to create an ambiguity which, according to the ordinary meaning of the words, is not there. So the starting point is to examine the words used to see if they are clear and unambiguous. And we say that approach is long-standing, is common sense. And the contention in this appeal that all that's required is some sort of plausible argument would turn the construction of an employment contract into a game for lawyers. And we make under this head three discrete points. First, we say that the maxim has always required a genuine ambiguity. And we say it would be very surprising if the law required the court to impose on a party a construction that was otherwise than genuine, particularly an employment contract. And if one looks at the authorities themselves, if I start with Ray Barden, please, which is page 1744, or in the hard copy, volume 4, tab 51.
I'm so sorry, I missed the electronic.
So sorry, it's 1744.
Thank you.
And I can probably take it a little more shortly. As I say, it was about the construction of a deed, if one looks at the head note at 1744. But again, the facts themselves probably don't matter too much for our purposes. The question, though, was how that deed should be construed. And then one sees the analysis of Lord Justice Harman at page 1755, the very foot of. The matter therefore stands thus, that construed as a trust, the deed must fail and produce a resulting trust for the settler, but if it be construed as a power, it may yet prevail. I'm of the opinion the court is at liberty if considerations on both sides seem evenly balanced to lean towards that which may effectuate rather than frustrate the settler's intentions. This is a true application of the doctrine of saving the document. And then the important passage follows. I won't read it out. But what's perfectly clear is that Lord Justice Harman is not suggesting for a moment that this doctrine would apply if there weren't genuine ambiguity. Cannot fly in the face of the teeth of the provisions. So that's Ray Barden. In the same volume, for those in the hard copy, electronic reference 1783, please, is the IRC case.
Rebaden was a case where the principle rather than the restriction upon it prevailed. In other words, he did apply the validation principle.
Yes,
Yeah.
yes.
I mean, judges quite often express in quite broad terms the nature of restriction to show that they're not mindless of it when they decide to apply the underlying principle notwithstanding.
You don't have to reply to that.
Well,
A bit of self-revelation.
I accept that may be true, but we would very respectfully say, and we started with Ray Barden, but actually Ray Barden is then followed again. And in fact, if one looks at if one looks at the next case, again, one sees the same sort of balancing exercise being carried out. So as I say, it's 1783, the IRC case, behind tab 53 in the hard copy. And it's a tax case, and one finds the key passage at page 1787, please. At the foot of that page, Mr. Justice McGarry cites Re Barden and says this at H: it is possible that the same approach might be adopted where the scales are tilted only slightly to one side or the other, but plainly it cannot apply where, apart from the effect of the rule against perpetuities or some other sources of invalidity, the court reaches the conclusion that one construction is clearly preferable to the other. And again, we say no more than that is consonant with looking for genuine ambiguity. One sees a similar approach by the Court of Appeal. I wasn't going to turn this up, but I'll perhaps just give you the reference to the extent that you want to look further. In the Tyndall-Cobham case, the reference to that is page 2050, where Lord Justice Patton was part of the court. Obviously, he was part of the Tillman court as well. And again, I'm not going to turn it up if you'll forgive me, but I would mention the Warner-Lambert case, the reference for which is 2240, a decision of my Lord Briggs in the Court of Appeal, which was looking at, oh, forgive me, in this court, my fault, which was looking at the question of the application of the doctrine in the context of patents. And I don't go back to it, but I note that my Lord Briggs said at paragraph 93 that in the past it had been applied to patents, but that its importance in modern times had been greatly diminished by the emergence of a purposive construction as applied to contracts and legislation as well as patents. Now, for the purposes of this appeal, I don't need to say that the doctrine of saving the document has been diminished. I'm content to say it stands with genuine ambiguity. But we would adopt, with the greatest of respect, what Lord Briggs said in that case, that it is difficult to see, once one has a modern purposive analysis, that there's much work left for saving the document to do, and it certainly doesn't come back in to trump the analysis at the end stage. As I say, I hope you'll forgive me for not going to that particular authority.
It's interesting, if you look at Justice McGarry's application of the principle in the IRC case, where a lot of people would describe that effectively as a purposive construction.
Yes. With respect, my Lord, yes. And that's where there's obviously an overlap between a lot of the canons of construction and a lot of the approaches. And that's why we do adopt what my Lord was saying, with the greatest of respect, in the Warner-Lambert case.
This is at page 2286.
88.
My lady, yes.
You think that these slightly different ways of describing the exercise are all that helpful, Mr. Eidkirk? You remember when we looked yesterday at Sir Kim's book, the quote from Lord Justice Toulson, are there two constructions capable of validity? If so, etc., etc. They've all expressed themselves slightly differently, but can't we take a fairly broad brush to this and not dance on the head of a pin?
With respect, my Lord, precisely. One doesn't need to dance on the head of a pin. One can take a broad brush approach. They're all saying the same thing. Whether one says, as long as you don't tilt too far one way, genuine ambiguity, it amounts to the same thing. But what they don't invite, we say, is the manufacturing of an ambiguity.
No, fair enough.
So that's the first point under this head, if I may. The second point is that if one now focuses in on the particular context of this case and says, well, is the requirement, as we would have it, of a genuine ambiguity important in the context of an employment case, we would say that an employment case is an a fortiori case. And one sees that in the Mont Mills case and the decision of Lord Justice Simon Brown. The reference is 1063, or volume 1, tab 15, please. And if I could, so that's where the case begins, and the passage I want to look at then begins at 1066, please, my lady. And it begins at paragraph 25, which is the foot of page 1066, where he refers to Mr. Carr's impossible submission. And he then says that this is one of those cases where there's been no attempt to formulate the covenant so as to focus upon the particular restraint necessary to guard against the defendant's possible misuse of confidential information. There's no question of the present covenant suffering, in Linley's words, a mere want of accuracy. And if I just pause there, that, when we look at the covenant, is this covenant. What you've got is a very broadly cast covenant. It's not that there's a want of accuracy. It's that there is an extravagant overreaching. And then the policy comes in the next paragraph, paragraph 26. There is, moreover, this further consideration. If the court here were to construe this covenant as the plaintiffs desire, what possible reason would employers ever have to impose restraints in appropriately limited terms? It would always be said that the covenants were basically just and honest and designed solely to protect the employer's legitimate interest in the confidentiality of their trade secrets, rather than to prevent competition as such. Thus would be perpetuated the long recognised vice here of ex-employees being left subject to apparently expensive restraints and yet quite unable, short of expensive litigation and the peril of substantial damages claims, to determine precisely what their rights may be. This case.
So when you say
Forgive
genuine ambiguity, what you mean is that it must not be one which the employer has, in effect, produced a situation where it has put forward a form of words on which it wishes to rely and then has to fall back. That would not be a genuine finding of an ambiguity.
My lady, with respect, yes. We would agree with that. And we would say that that's consonant with the basic principle of construction. If the employer's intention, when you read the clause, is to cast it as broadly as possible, it's very difficult to see that that clause is genuinely ambiguous. What the employer has in fact intended to do is to cast the net as widely as he can. Now, if he can justify that, the clause will be upheld. But if he can't, what the court won't do is say, oh, well, this is in some sense ambiguous. And so, and then one sees, and I'm not going to repeat them, but one sees, and I just perhaps draw to your attention, paragraphs 27 and 28 of the same judgment, reference back to the Mason case, to Lord Moulton's famous statement, which obviously we pray and aid in our printed case. And the language of 28 obviously mirrors in part the language that we have used in the propositions that we invite you to accept. So,
Where do we find the covenant in this case?
I'm so sorry, didn't take you to the covenant. So the covenant you find in the head note is the easiest place, so 1063, and if I just tell you what it was a one-year covenant in a severance agreement with an employee, and one sees that in the second paragraph of the head note, my lady. Not a particularly complicated covenant, but a covenant that's obviously too broad. So that's the...
Is one way to put it this.
Sorry, my lord.
Is one way to put it this, that if the only reason why the person looking at the covenant might think it was ambiguous is because if it means what it appears to say, it would offend against the restraint of trade doctrine, that of itself is too much of a bootstraps argument to permit the validation principle to be applied.
My lord, I certainly would accept that proposition. Yes. Because it does, as my lord say, it becomes bootstraps.
Yeah.
So then, if I may, the third point under this head, which is we say there is nothing surprising about the requirement for a genuine ambiguity particularly once one thinks about other canons of construction. And we would respectfully say an obvious example is the contra proferentum rule. I'm not going to turn it up, it's too well known, I think, probably to require a citation, but I'll give you the reference for where you see that in the authorities. So we've given you, if you look at MS 2109, that's a reference to judgment of Lord Justice Morbick, where he says that the contra referendum rule can be applied where the language chosen by the parties is one-sided and genuinely ambiguous, that is, equally capable of bearing two distinct meanings. So again, this concept of requiring genuine ambiguity before you engage these rather blunt canons of construction is something one sees not just in saving the document. And we actually pause and note, if I may, just coming back to the theme of how all the canons of construction fit together. How does contra proferentum actually fit with all of this? Because one might say, well, the employer's drafted this. There's a genuine ambiguity. You construe it against the employer. The employer says, no, I've drafted this. There's a genuine ambiguity. You save the document. So you almost have a collision there of these two canons of construction. Of course, the answer is the modern approach, contextual, doesn't resolve them using those blunt tools. But I throw it up, not as something that this court needs to resolve on this appeal, but it's interesting. We would respectfully submit tension. So that's all I was going to say on point 3. Can I turn, please, to proposition 4? And proposition 4 is that the non-compete clause prevents Ms. Tillman holding shares in a competing business as a matter of natural language. As the authorities and model clauses show, the phrase interested in is classically used to refer to a shareholding. And we have 5 subheads under this. The first point we make is one looks at the natural meaning of the words. That is the starting point. And those words are a classic way of referring to a shareholding. That is particularly so where they are prefaced by the words directly or indirectly, i.e. broadened. We accept, as we accepted before the Court of Appeal, that the words concerned or interested in do not have a fixed meaning. We have never submitted that they have a fixed meaning. We do not submit to this court that they have a fixed meaning. But that doesn't mean that you ignore the natural or classical meaning. To the contrary, that is the starting point. Similarly, if a draftsman looking to draft a contract wishes to refer to a shareholding, he or she will doubtless look to words which in the authorities have been used to refer to a shareholding. And we respectfully submit that this court rightly asked, what do the words directly or indirectly concerned or interested in add to the word engagement if this clause simply means active engagement? And there was no answer given to that, because there is no answer to that. Or at least no sustainable answer given to that. Now, we are supported in our analysis by the dictionary definition. I'm not going to turn it up, you have it. We've given you the shorter OED at page 1381, which refers to a financial share or stake in something, the relation of being one of the owners or beneficiaries of an asset. Again, common language. Again, I'm not going to turn up Arnold and Britton. This court will have well in mind what Lord Neuberger said at paragraph 16 of that case, that meaning is most obviously to be gleaned from the language of the provision, and the clearer the natural meaning, the more difficult to justify departure. This term couldn't be clearer. So that's the first point we make under this head. The second point we make is that the natural meaning has been adopted time and time again in the authorities. And if I can just look at one or two of those, please, not least because one or two we have to come back to under the next head in any event, so it's perhaps useful to introduce them. The first case is Smith and Hancock, which is page 1269. And in the hard copies, that's volume 2, tab 21. And while you're telling that up, perhaps I could just tell you what the case is about. It's quite a colourful case. I appreciate the court may have read it, but I'll just go through the essence. Colourful case in that the husband has a grocer's business, TP Hancock, and he sells the grocer's business, and he enters into a covenant, a vendor's covenant, not to be interested in any similar business. And a little bit later, he sets up his wife in a grocer's business, and that is called Mrs. T.P. Hancock. And perhaps unsurprisingly, the purchaser brought an action for breach of the covenant. What was said in the case, and again, if I just give you the facts, so Mr. Hancock said, in fact, being interested in a similar business prevents me having a pecuniary interest or a shareholding, but it doesn't prevent me working in it. And that case was successful. And can I just pick up, it's a very, very short judgment, but if I could just pick up what Lord Justice Lindley said at page 1278, at the foot of that page, or towards the foot of that page, he says this of the husband: what interest has he in that business? Certainly no pecuniary interest. His only interest is that indirect interest which every man has in the happiness and welfare of his wife. But to have such an interest as this is no breach of the defendant's agreement. When a person sells a business and agrees not to carry on or be in any way interested in any similar business, the word interested is used to prevent him not only carrying it on, but also from having any proprietary or pecuniary interest in it. So I don't invite you to adopt all of the propositions in that paragraph, but insofar as we're concerned with an interest amounting to a pecuniary interest, one sees immediately what the court considered the meaning of those words was. And then to similar effect, if I may.
Well, what do we mean by the word interest if we talk about a judge having an interest in a case? We don't, of course, mean being interested in the case. We mean having a pecuniary interest in the case, directly or indirectly. I merely ask.
Well,
Though
it
an
becomes,
interest in the happiness and welfare of his wife might well qualify, of course.
I accept that it becomes contextual. There's no difficulty with that. But one sees immediately that in this context, interested in, connotes a pecuniary interest. And one sees that also in the second judgment, the judgment of Lord Justice A.L. Smith. If one just picks that up at page 1282, at the foot of the page, 6 lines up. Now the covenant is that the covenantor will not carry on nor be in any way interested in a business of a character that is similar to that sold within the prescribed limits of time and space, which in my judgment means he will not carry on by himself, his agent, such a business, nor will he be anywise have any interest, be it pecuniary or personal, in such a business. So that's how it's seen in that case. And of course, they conclude, and I don't think I need to deal with the rest of the detail, that he didn't have such a pecuniary interest in the business. So Smith and Hancock illustrates the way interested in or interest was looked at over 100 years ago. Turning forward 100 years, one can look in the same hard copy file behind tab 22 or in the electronic bundle at page 1285, please, at the Court of Appeal's decision in the Scully case. And again, just to introduce this case very quickly, at page 1285, one sees the clause, if I may, in the head note at 17C, which is really effectively the third paragraph. The employee shall not, during the period of 12 months, commencing with the termination of his employment hereunder, carry on, assisting, carrying on, or be engaged or otherwise interested in, so those are the words we see here, whether as a shareholder, director, etc., or in any other capacity. So that was the prohibition in Scully. And then the judge's decision can be picked up at paragraph 24. I'm sorry to take this case quite quickly, but these are the key components, if I may. So at 24, you've got the judge's decision, and really the electronic page number is 1289. I should have given that before. And so in the middle of paragraph 24, in the judge's judgment, it says this: in my judgment, the period of 1 year as to duration of restraint is not excessive, since lead times for the introduction of new products are often substantially greater than that period. If the reference to shareholder were confined to a majority shareholder or a shareholder with a controlling substantial interest, it would, in my judgment, be unobjectionable. But covering as it does the more likely situation of a small shareholding, it is wider than necessary to protect the plaintiff's legitimate interests. So, judge at first instance, broadly saying, you need a carve-out for small shareholdings, which is what one sees in the Camelling extract I handed up this morning. The law's perfectly clear in 1998. And then if one just looks at paragraph 25, Mr. Tabachnik did not challenge the judge's conclusion that the clause went wider than was reasonable insofar as it restricted Mr. Lee from being interested as a shareholder or in any other capacity in any business, etc., etc. So there wasn't a challenge to that. What was said was it could be severed. And I just need to show you, so you understand what parts of that clause caught a shareholding. Paragraph 33, please. Now, obviously, we will come back to this in the context of severance. That's a different proposition. But broadly, they apply the separate obligations test, which is outward. And then at 33, you'll see what they say. It might be possible to sever the obligation not to be interested in an advertising business by deleting the word advertising. That obligation, etc., etc., might be said to be trivial. However, the same cannot be said of the other restrictions, which are not reasonable to protect the legitimate interests of Scully. To do that, the words otherwise interested, shareholder, or in any capacity would need to be altered or deleted. So, pausing there, it's not just shareholder that would have to be deleted to save the clause. The words otherwise interested also catch a shareholding. So that's the Scully case. And again, I'm just going to give you a couple of more examples, if I may. The William Corey case is also, we say, instructive. We looked at this very, very briefly with Mr. Laddie. It's page 1312, or in the hard copy, volume 2, tab 25. Now, the facts of this case are, it's a very short report, they're quite complex, and I hope you'll just forgive me just for telling you how we say this case fits together. What it was about was this. Whether if someone had a shareholding in company A, and company A was a creditor of company B, whether it could be said that the person who had the shareholding was in fact interested in B, the end company. So there are two jumps, if I may say, in that. First, to be interested in, the interest in the first company is obviously qua shareholder, but then the second company's interest is as a creditor. So one can see, it'd be quite surprising if that's what interested in meant. You know, I'm a shareholder of Company A. Company A happens to lend some money to C. I'm now interested in C's business. But what's very interesting about the case is it proceeds on the premise that the shareholding link is good, i.e. having the shares would be interested in. The difficulty is the creditor limb. And that's how it works. The reason I've dealt with it in that way is it's complicated by the fact that every company is called Harrison in that case. C.W. Harrison, J.C. Harrison. So if one explains it by reference to the actual companies, it does become, speaking only for myself perhaps, hard to follow. And that's where one then gets, at 313, the Earl of Halsbury, you were taken to what was said in that first part. It would be impossible, I think, to lay down with precision what is or is not comprehended by such words interested or concerned in. You must look at the facts of the particular case. As I say, we don't shrink from that. But what one has to have in mind is that the proposition in that case was that by having a shareholding in someone who then was the creditor of another company, you had an interest in that end company. The result, as the Court of Appeal said, would surely have been different if it wasn't ABC, but actually if it just ended with shareholding in the next company. So that is the William Corey case. We say actually on a proper analysis, it supports our approach. And then finally, just to look very quickly, a couple of the first instance authorities. First, a decision of Mr. Justice Silber in CEF, which is page 848, hard copy, volume 1, tab 5. And if I, again, just show you how it works very quickly, if I may. The clause one can take at page 848 from the head note in the middle paragraph. And in the middle of the middle paragraph, it begins unlike the general manager. In the middle of that paragraph, you'll see the non-competition clause provided that you will not be engaged, concerned, or interested in, etc. So again, echoes the gist of our clause. And what was said, one can pick up again in the head note at paragraph 3, so that's overleaf 849. The non-competition clause was unenforceable, and about halfway down, further, the width was so great that it prevented any employees from having any interest in a competing company, such as even owning one share in a publicly quoted company. That's the approach at first instance, and I can just give you the reference to that in the judgment. Not that it adds anything, but it's at paragraph 65, page 858. So, again, we say all of this right up to date, really, is consonant with an approach that's been taken over well over 100 years. One sees that also in the Goffier Diamond case, which is page 952, please, or in the hard copy, volume 1, tab 7.
So sorry, I missed the electronic number.
I'm so sorry, my lord. I think I said 952.
Thank you.
And one sees that at 952, so this was a motion by the plaintiffs to restrain the defendant from being interested directly or indirectly in a similar business. What is said, I'm taking it very quickly, but what is said at the in the judgment, page 955, the covenant fairly construed prohibits the defendant from being interested directly or indirectly in a similar business in the sense that he must not have a proprietary or pecuniary interest in the success or failure thereof. If his remuneration in any way depended on the profits or gross returns, he would be interested in the business. But the mere fact that he's employed as a servant at a fixed salary gives him no such interest. So the short point that one sees from that quote is that it's construed as meaning a proprietary or pecuniary interest, but also, if we just draw this out, that whilst that would obviously encapsulate a shareholding, it might also encapsulate some other interest in a revenue stream. It's not limited to shareholdings. It could be that someone gets 10% of a particular revenue stream. And I'm not going to go to this one because it's probably too many cases, but if you want to see an example of a direct interest in the turnover of a business, which is not about shares, then that's the Sab Miller case at page 2017, at paragraph 133.
Making this submission with reference to the submission that the interest must be in an activity as opposed to a company.
I certainly don't say it must be in an activity as opposed to a company. I say that it can be in a company, it can be in an activity. It covers both.
It covers both on your side.
Respect my lady, yes. The last case I was going to look up under this head, and again it does save a little bit of time later because we have to go back to it, is the decision of Lord Justice Younger in the British reinforced concrete case. And that is at page 830. And this case proceeds on the basis of a concession, but it's a concession that the judge plainly thinks is rightly made. And what is said at page 838, if I just take it from there, I'll show you the clause and then what happens. So at page 838, in the middle of that page, you've got the agreement, and he says that the agreement precludes him, quotes, from acting as a servant of any person concerned or interested in the business or manufacturer of road reinforcements. And then the judge says this, but after it had been pointed out that that part of the covenant would preclude Shelf from becoming the servant of, say, a trust company, which as part of its investments held shares in a competitor, it was accepted that the restriction was invalid. So in other words, it was accepted that a clause that prohibits you from acting as the servant of someone concerned or interested in a business catches the circumstances where the person you're working for has shares in that business. Now, I accept that that was a concession in that case, one, as I say, that Lord Justice Younger plainly thought was rightly made. But it's, again, consonant with all of the cases in this area. And then really finally under this, I said I had 5 points under this head. The third point I make, and I say one looks at the model clauses settled on the basis of the authorities. The fourth point I make under this head is commercial common sense. Insofar as recourse has to be had to commercial common sense, it's striking that the appellant has been driven in this appeal to arguing that as a matter of commercial common sense, these words were not even intended to catch a 100% shareholding. And it's very striking that that argument is put forward by the appellant. And pausing for a moment, had I appeared for Ms. Tillman, who had a 100% shareholding, and Miss Laddie had sought to enforce this clause and said it caught it, I suspect I would have been given short shrift by a judge at first instance if I said, oh, well, it's not intended to catch that. So that's commercial common sense. And then, fifthly, we say, it's a very short point, that really the issue at the heart of this case is not that there's an ambiguity in the covenant, but as I said really at the outset, that the covenant has been cast in impermissibly wide terms. That's really what's going on. Finally, one first instance decision which is prayed in aid is the Gambaroni decision. I'm not, given the time, going to turn that up. But we would say this. First, it's a different case and a different contract. It actually does need to be looked at with a little more care. In fact, in that case, you had financial interest referred to in one clause and interest in another clause. So it wasn't this case, it wasn't interested in two clauses meaning different things. It was financial interest plays interest, so that's point one. Point two, and I'm summarising what much longer submissions, point two is that the history of that clause is it had previously been construed by the court as enforceable, rightly or wrongly, and only covering activities. And that was 10 years previously. So it would be a bit odd for another court then to say, well, although we've construed it as meaning activities, we're now going to construe it differently. And the third point we make is that Mr. Justice Foskett made very clear in that case that he was construing that particular contract, which, as I say, had an unusual history.
So perhaps should we, you'll be coming on to context, but you spent a lot of time, I don't criticise you in any way, exemplifying by reference to masses of cases,
Yes.
what you call the classical construction.
Yes.
But we've been told time and time again, you've got to construe in context, and you'll be coming on to that.
Yes.
Probably sooner rather than later.
My Lord, yes. I finished under this head, and I'll have well in mind my Lord Wilson's point. As I said, I just wanted to cover that, and we really say that case doesn't decide any point of principle. It's a first instance decision, whatever the rights or wrongs of it. So that takes me, if I may, although I obviously have well in mind my Lord's point, to my fifth proposition, which is severance. And at proposition 5, then, we say that the appellant accepts that this non-compete clause can't be justified if it catches a shareholding. It can only be saved by severance, and we say it's not permissible here. First, we say a restraint such as this one, which purports to prevent an employee from having any part or lot or involvement in a competitor, comprises one integral obligation and cannot be severed. Secondly, we say severance is only permissible where the parties have agreed two restraints separate from the other, not dependent one on the other, not one integral obligation. And then thirdly, under this head, we say Beckett did not change the law and dispense with the requirement for separate obligations. Beckett follows Atwood and Lucas. Severance without separate obligations is not permissible, since that would change the sort of contract the parties entered into. We say that those propositions are amply supported by authority. So the starting point, if I may, this segues neatly into the point that my Lord Wilson asks, is what does this clause do in this context? And we say this is a clause which bars all access to a competitor. It prohibits any part or lot. It is, to use the slightly old-fashioned words of the authorities, a covenant in mosaic. It's one integral clause. And just as the words part or lot are not severable, so this clause is not severable. And it's not severable whether one applies what we say is the correct and orthodox test, or whether one applies the touchstone of justice, some looser test. And we say that the appellant's invitation to this court to abandon the requirement of separate obligations would be a dangerous departure from the fundamental principle that English law does not rewrite contracts. And can I just before we get into the weeds, just give you three obvious difficulties with the approach of the appellant. First, it's actually very difficult to see how judges at first instance could produce consistent and predictable decisions if the only touchstone is justice, or if the only touchstone, as put in Sadler, is not the sort of contract the parties entered into. One judge's impression as to whether it was not the sort of contract the parties entered into might not accord with another's. That's particularly so where these will be dealt with by non-specialist judges, urgent applications. It's quite common in the Queen's Bench Division for only an hour to be allocated to the hearing of an interim hearing. But leaving aside the difficulty in which the judge would be placed, and even assuming the employee had legal advice, the legal advisors of the employee would be hard-pressed to say meaningfully how the case was going to be decided. And it comes back to, as I won't turn it up because of the time, but as Lord Sterndale said in the Atwood case at page 795, figurative language can lead to misunderstanding. Now, those words are, we say, important because the advantage of the separate obligations test is that it's a legal test that can be applied, has been applied for over a century. The second point we make under this is if there are not separate obligations, there can be no severance because English law does not permit rewriting. And the point there is what is the court doing if there are not separate obligations? Once one accepts, as Chitty states, and I think it's, I'll give you the reference, 1357 in the bundle, paragraph 16, spot 239. But I mean, it's obviously, I'm sure, common ground that English law does not permit the rewriting of a contract. Then if you can't find separate obligations, you can't sever without, you can't sever any part.
When you say separate obligations, do you consider that it is permissible under the law as it stands to delete just a few words within a clause?
Well, if, when you look at the clause, and I'm going to come and look at some examples, if when you look at the clause, you can see that the few words are a separate obligation, then yes, it may be possible to sever, but not if you can't identify that separate obligation. And the reason the authorities spend a lot of time talking about part or lot clauses is even if one comes back to the modern approach and says, well, look, I've got to look at the intention of the parties when they drafted this clause. Were they drafting two clauses, separate obligations, or was this intended to be a complete bar on competition, a part or lot clause? If you can see that the intention of the parties was an obligation that prevented someone having any part or lot of a business, it's one integral obligation. And it's one integral obligation whether you say you shall not have any part or lot, or if you write out a list of the 50 or so parts or lots you shall not have. Because it's still one integral clause. And one, as I say, if one looks at it in modern terms, one can see what the intention is. The other point I wanted
Granted that you accept that you don't just look at the format of the contract, you go further than that. Do you think your separate obligation test is any easier for the hard-pressed judges than what has been said to be the modern test?
With respect, yes. Yes, because it is ordinarily possible, if you're severing, either to identify separate obligations or not and not sever. And just pausing for a moment, to the extent that it said it's difficult for the judges, severance should only take place on the authorities where the position is clear, where something is clearly severable. The pressure that having a rigorous test on severance exerts is not on judges, it's on employers to draft contracts in the right form. Because provided the employer identifies properly tailored clauses, as he could have done in this case, one doesn't ever fall back on severance. So there's no, we would respectfully say there's ultimately no mischief here. And can I just, it's probably useful to deal with this at the outset, just to show you where I'm going. It's important when one looks at Sadler and Marshall to understand what's happening in those cases. So in Sadler and Marshall, they're not restraint of trade cases in the classic sense. What you've got in Sadler and Marshall, both of those cases, is that A owes an obligation to B. So the employer, say, owes an obligation to pay some money to B. And B owes an obligation back to A. The employee owes an obligation, let's say, not to compete. Those are the two obligations. They are separate obligations in the Sadler sense, forgive me, in the Atwood sense. No doubt that they're not, because they're owed by different parties. So the work that needs to be done in a Sadler or a Marshall case is not, are there separate obligations? With the greatest respect, Lord Sumption plainly well understood there was a requirement for separate obligations, but that was not the problem he was faced with. The question is, having identified separate obligations and then deciding that you're not going to enforce one party's obligation, so the employee, you say, well, fine, you don't have to be restrained. The question then is, does the court enforce the employer's obligation? And that's why you get in Sadler and in Marshall the court saying, should I enforce it? Is it the sort of contract that the parties entered into? And that it's very important to understand that that is the context of Marshall and Sadler. And with greatest respect, as Lord Justice Millett said when Marshall went to the Court of Appeal, he said, that is, and I quote, a very different question to the question which arises in the restraint of trade cases. And we'll come and look at that. I'm not shrinking from it. I'll just give you the reference now. That's MS 1841. And so to the extent that anything has gone wrong, we say that both Sadler and Marshall well understand that you need separate obligations. This hasn't gone away. It's simply that the question for the court in that case is not, are there separate obligations? It knows that. It's what do I do having severed? So can I also now look at this clause? And the clause itself is at MS 188, which is core 1. And just to pick it up and to deal with my Lord Lawson's point. So what one sees here, we say, is a clause which is cast in the broadest possible terms. This is a classic part or lot case. If one asks, if you can enforce this, then, or somehow start blue penciling this, then frankly you can blue pencil anything. Employers might as well just write a long list, as broad as possible, and hope that something sticks, which is not the approach. If one just looks at it, 13.2, directly or indirectly, so that's our first directly or indirectly to make sure it's nice and broad, on behalf of any third party, whether it's principal, manager, employee, contractor, etc., or otherwise howsoever, again, those words are broadened, and then the offending clause, 13.2.3, directly or indirectly, again, making the words engaged or be concerned or interested in, which are already broad words, as wide as possible, in any business carried on in competition. That is the broadest imaginable prohibition on competition. It's the classic part or lot clause. And that's why I say, although I press my separate obligations test for severance, this is the sort of clause that can never be severed. It's just too broad. And as a matter of policy, that must be right, because otherwise the employer is always going to be in a better position if it drafts the clause in these ridiculously wide terms. Because it can always come to the court and say, strip it down, or just say to the employee, I'll come to the court and the court might rewrite it. And you can't take the risk, which may not be this case, but will be many cases. Can we make another point in passing while we're looking at the clause? You'll note that at 13.2.1, there's a a non-solicitation or deal clause, for example, it bears repeating that Mr. Laddie's livelihood test on restraint of trade is that a clause is only in restraint of trade if it stops somebody from earning their livelihood. What if you had a non-solicitation clause which limited someone and said they couldn't deal with 2 clients, just 2 clients? So it wasn't going to affect their livelihood, but the employer wanted to protect 2 clients. On Mr. Laddie's analysis of restraint of trade, the restraint of trade doctrine would not apply at all. Obviously, it applies to a non-solicitation clause. But it's a point in passing, but it's perhaps instructive. So we say, if one looks at the key covenant here, 3.2.3, it's cast in the very broadest of terms, interested in is preceded by the words directly or indirectly. And to put it in its commercial context, if one asks oneself the question, what would the employer want to do at the point that the employee is leaving? Here you have an employee who has joined from a very successful background, who is leaving in the recruiting industry, who may well want to set up, invest in a competing business. It's exactly the sort of thing that an employer would want to stop. In fact, the sort of cases you see in the Queen's Bench Division are very often cases where the employer says, we want to stop a startup. There is a startup business happening. So if one's construing this clause, we say the one thing you wouldn't do is to construe it so that interested in doesn't catch a shareholding. And we say it is, again, in answer, if I may, to my Lord Wilson's point, instructive to reverse the question. Imagine I were here today and it was said that Ms. Tillman had, when she was leaving, put 30%, 70% into a startup recruitment agency. And I were there before the judge saying, well, as a matter of commercial common sense, this clause isn't designed to stop that. I do say that that's an almost impossible submission. Because someone would say, well, hang on, Mr. Alcock, it stops your client being indirectly or directly interested in a business. How can she not be interested in this business in circumstances where she's got a 70% shareholding? So one can see immediately what this is designed to catch. It's just too broad. So that's the clause itself.
Can I just test?
Of course, yes.
I think what's emerging from your submissions is that the way in which you test whether an allegedly severable obligation is a separate obligation from that which remains may be answered by asking whether it's part of a mosaic which, when aggregated with everything else, adds up to an identifiable whole. If you apply, I'll loosely call that the mosaic test. If you apply that to clause 13.2 as a whole, you might say that sub 1, sub 2, sub 3, sub 4 are all bricks in a large mosaic, such that you couldn't even sever off non-competition from non-solicitation. I don't think you go that far.
No, I certainly don't go that far.
But then how do you get out of the problem that actually, if you look at 13.2, you could regard the whole thing as a piece of mosaic?
Well, we would say one doesn't really quite get into that problem, because what one has is, typically one sees a non-solicit clause, a non-deal clause. Those are obviously separate concepts. And in fact, classically, whether you express a non-solicit clause as separate to a non-deal clause or a non-deal clause in the same line, as it were, those are viewed as separate concepts which are severable, as one sees on the authorities. Whereas if one just rows back and looks at the non-compete clause, what you're saying, and if I may say, my lord, it almost comes back to the intention that you see when you look at the clause. See, in order to say that a clause which is in mosaic has separate clauses in it, you would have to say, well, the intention of the parties here was effectively 2 separate concepts, not to prevent any form of competition. Can I do it by reference, if I may, my lord, to the authorities? Because we do say that, I sort of jumped away from them in answer to my Lord Wilson's question, but we do say it's pretty clear on the authority. So the part or lot expression obviously comes from the British reinforced concrete case that we started looking at, and that's at page 830. And so the judgment itself is at page 573, page 840 of the electronic bundle, and the key part of the judgment is there. And so what's said is, I cannot think, after Lord Moulton's observations in Mason's case, this process will be extended, even in the case of a vendor's covenant, to a case not hitherto covered by authority, where the excess is not trivial, and is part of the main purport and substance of the clause. So what Lord Justice Younger has in mind is the main purport and substance of the clause. Its application does not authorise the making of a new contract for the parties, and the particular clause now in question is really a principle, if not the main approach to the business of the sale of road reinforcements, all access to which it is the purport of the covenant so to bar, so as to prevent the covenantors from having any part or lot whatsoever during the period of restriction. Like the covenant in Atwood and Lamont, it is merely part of one entire covenant in Mosaic, and to permit the severance would, I think, be to go further than has ever been permitted in such a case. So again, old-fashioned language, perhaps, but what Lord Justice Younger is identifying there is a clause which is intended to be a bar on all access, where the employer says, no, I didn't intend this to be a bar on all access. You should write it down so that it's a partial bar. And so severance in that case refused. Now, one then gets to the Court of Appeal cases, and as I say, we do say that the separate obligations test, as you'll see, it really has stood the test of time. So if one turns to the Atwood case, which is electronic file 788, now, I don't know if we looked at the clause here, but it's perhaps important to do so. What is said, can I just answer, actually, while we look at this, a question that my Lord Wilson, I think, asked yesterday, which is noting that Lord Justices Younger and Atkin, agreed, whether the Master of the Rolls dissented in any material respect. The answer to that is they all agree on separate obligations. Lord Justice Younger and Lord Justice Atkin think that there is, even if there are separate obligations, there's some third discretionary stage. So that's the difference between them. But for the purposes of separate obligations, this is a unanimous Court of Appeal.
Thank you.
So the clause one sees in the head note, either on his own account or on that of any wife, doubtless that is a reference back to the Hancock case that we looked at, of his or partnership as assistant, servant or agent to any other persons or company, carry on or be in any way directly or indirectly concerned in any of the following trades or businesses, that is to say the trade or business of a tailor, dressmaker, general draper, milliner, hatter, haberdasher, gentleman, ladies' outfitter, etc., etc. Now, the point in that case is that this is a part or lot clause. You will have no part of any part of my business. It's one integral clause. And the point that the Court of Appeal is making here is you don't distinguish between a clause that says you will not have any part of my business and a list of all the parts of the business. so that the employer somehow later can go, well, actually, it suits me to select these two parts. It's one integral clause. That's the thrust, the purport of it. There's nothing surprising about Atwood. It's difficult to see how that clause could be construed in any other way. And just picking up what was said by their lordships, please, at 598.
Electronic.
Sorry, I misspoke. 798 electronic. I'm so sorry, my lord.
Right.
And that's a reference to, say 7. Yes, actually. Forgive me. Just wondering if it's worth starting earlier. No, we'll start, if I may, at 798 then, at what Lord Justice Younger says, 2/3 of the way down the page. Now, we are here dealing with a branch of the law which has at all times been peculiarly susceptible to the current views of public policy, etc. This is a public policy point. And then over leaf, the point I made earlier this morning in relation to the way in which policy works in this case. And then severance comes at page 810. And what is said at 810, I agree with the Master of Rolls that this is not, and that reflecting what I said earlier, that they were unanimous on this. Master of Rolls, that this was not a case on which any principle this severance was permissible. A learned judge of the divisional court, I think, took the view that severance was always permissible when it could effectively be accomplished by the action of blue pencil. I do not agree. The doctrine of severance has not, I think, gone further than to make it permissible in a case where the covenant is not really a single covenant, but is in effect a combination of distinct covenants. In that case, and where the severance can be carried out without the addition of an alteration of a word, it is permissible. But in that case only. Now here, I think there is in truth one covenant for the protection of the respondent's entire business, and not several covenants for the protection of his several businesses. The respondent is not on the evidence carrying on several businesses, but one business. And in my opinion, this covenant must stand or fall in its unaltered form. Now, Atwood may be one of the more difficult cases, reflecting the fact that it reached the Court of Appeal. I don't say there will never be difficult cases, whatever test you have, but that's not, in our respectful submission, a surprising landing at all. If one stands back, it is obviously one integral covenant for the entire business. And the confusion comes when it's suggested, oh, well, here there was a list, and because it's a list, you can start crossing things through. That's simply not the approach of the court. So that's Atwood.
Yes, the divisional court had taken a different view.
Yes.
They'd accepted that if it was indivisible, you couldn't sever. But they construed the contract as not being indivisible. You pays your money and you takes your choice.
My Lord, yes. And my Lord, if I may say, makes an important point, that the divisional court was also unanimous, or agreed with the Court of Appeal, on the question of whether you require separate obligations. See, what runs through this, and we'll see this when we look at all of the Court of Appeal cases, is no one has said you don't need separate obligations, for the basic reason, as one sees in Atwood, that English law does not rewrite contracts. Forgive me, my Lord.
But the gist of the point that my Lord Wilson is putting to you, I think, is that the very fact that two distinguished collegiate courts could reach the opposite conclusion applying the very same test gives the lie to the proposition that by using the Atwood single obligation test, you solve all the problems for busy judges dealing with urgent interim applications. Well, and no doubt one would also think about Mr. Alexander coming in from a slightly different field than his main field, crying in the wilderness about this problem in the case which was added in the extras. I forget the name of it.
My Lord, yes, but
the foods case.
We would say this. First, whatever test you have, you will always find cases, construction is perhaps a good example, if one looks at the number of construction cases that reach both this court and the Court of Appeal. And we'll always have cases where experienced judges actually end up taking different views. In fact, we would say that the separate obligations test, and I'll deal with the other authorities, but if you remember that it has been in place for over 100 years, one doesn't really see that it has been problematic. I accept completely that there will always be difficult cases on any test, but it's still a perfectly rigorous and applicable test. Secondly, and we'll look at Fresh Asia, much of what is said in Fresh Asia reflects the difficulty which arises from not the separate obligations test, but from what is said sometimes by counsel to be this tension between Sadler and Atwood. Once one understands that one needs separate obligations, we would respectfully submit is a perfectly applicable test. And indeed, if one asks the question, what is the appeal court to do with it? If one has a real test like that, then one can appeal, because the court can look at it and say, well, this is the test I'm applying. If the test is simply, it's not the sort of contract the parties entered into, very difficult to see how anyone would really clearly know, with respect, where they stood.
But does the test pronounced by Lord Justice Younger that there must be separate obligations differ in substance from the proposition that the severance must not alter the nature of the obligations?
We would say it shouldn't, because we say properly understood, Sadler was not dispensing with that. And as soon as you rewrite a contract, which English law doesn't do, it's not the sort of contract you entered into. So it amounts actually to the same thing. What we do say, as we have said, is to the extent that it's helpful to restate that part of that exercise is looking for separate obligations, that can be done. But what one doesn't see in truth is that over the 100 years, a real difficulty with it as a test. Can I just deal with some more of the cases, because I simply want to get through them, if I may. If one looks now at the Lucas case, so Lucas is at page 1006, please, or file 1, tab 10. And this was a non-solicit, non-deal clause. Classic separate obligations, in fact. Sometimes one sees them written down separately. Sometimes one doesn't see them written down separately. It doesn't ordinarily matter because they're separate concepts and you look at the substance, not the form. And if one looks at what the court did in Lucas, if I can perhaps begin it at page 1012, please. So, as I say, they're construing a non-solicit, non-deal clause. I should perhaps show you that in the head note. So in the head note, it's at 1006. Deal in any good, similar, or capable of being used in place of allocated articles or solicit orders for. So one would have thought separate obligations. And let's look at how the Court of Appeal approach it then at 1012. E, in our judgment, Clause 16 is properly to be regarded as not merely a single obligation not to solicit or supply, but as two separate obligations or restraints, one against dealing and the other against soliciting and supplying. This, it seems to us, is a matter of construction, including the question whether one obligation can be removed or severed without altering the nature of the contract, etc., of the words. So, and can I, actually, I was going to read on because it also answers a question I think that my Lord Justice, Lord Briggs, forgive me, asked yesterday about whether the words are still available. Do you see, my Lord, that at F?
Oh, yeah.
Your shadow construction point, if I can put it like that. Just draw your attention to that. But the point, I don't want to get too detoured by that, but as I say, I thought I should draw it to your attention. The point here is that in Lucas, the Court of Appeal are applying the separate obligations test. They're not saying this is a very difficult test to apply. No difficulty applying it. And this is the case which is, and then if one just looks over, they do identify a difficulty with Atwood and Lamont, but it's not the separate obligations test as Mr. Laddie would have it. If you just look at the foot of that page, page 1012, at H, the real difficulty that arises on authority lies in the apparent views of Atkin and Younger that there is a third step taken by the court when it finds two restraints in collocation which are severable, which we apprehend means that the parties have agreed two restraints separate one from the other and not dependent upon the other, nor constituting one integral obligation. The third step supposes that it is for the court in a master-servant case to decide whether or not to treat the two restraints as separate. Now, I don't urge the third step on you. But what this underscores, we would respectfully submit, is that far from the Court of Appeal and the courts struggling to apply separate obligations, Lord Justice Russell thinks that separate obligations is a perfectly sensible test. And indeed, we adopted his formulation in our propositions. The parties have agreed two restraints, separate one from the other, not dependent on the other, nor constituting one integral obligation. The only difficulty he has with the case is master-servant. It's third discretionary step. So to the extent that at paragraph 75, I think it is, of my friend's printed case, he says Atwood is doubted, it's not. And that's, we see later when we see Beckett, they say the only point in Atwood that has been doubted, it's that third step. Forgive me, my lord.
I was just going to say, if you apply your mosaic test to the facts of this case, why isn't don't solicit and don't deal just a two-brick mosaic saying don't have anything to do with our customers?
Because that's precisely what they're not doing. We would respectfully submit that if you say to someone, do not solicit, do not deal, there are two clear concepts there. Yeah. Conversely,
yes, conceptually clear.
Yes. Conversely, the one covenant that the court will never uphold is a covenant against competition only in a master-servant case. And if you look at the mosaic here, it's a mosaic against any form of competition, any involvement whatsoever. So it is automatically a part or lot clause that bars all access. The non-solicit, non-deal is two separate covenants. Another way of looking at it would be this. If you ask yourself, what is the employer trying to do when it writes down, you will not solicit, you will not deal? Its intention is to prevent the employee from soliciting. Its intention is also to prevent the employee from dealing. Those are two perfectly understandable, and we would say separate obligations. If it writes down, you will not be concerned, interested in, have any part or lot of, have any involvement in, etc., that's one integral clause designed to catch everything. So we do respect, and the law, we would also say, hasn't struggled with this. We would also, though, finally say that actually an employer well advised, although the law does treat them as separate obligations, would actually normally just put them in separate clauses. And there isn't really any difficulty with that, because this all comes back to, does the law encourage employers to draft contracts sensibly, or does the law go the other way and say, well, we're going to give the employer plenty of latitude? So that's what we say about the Lucas case. Can I
just, before you go there, I'm not quite clear why you don't urge on us the third step in Atwood, because it's merely the inverse, isn't it, of there being separate obligations. It helps understand what a separate obligation is. If one looks at the facts of Atwood, you have the long list, and there was effectively a company policy to prohibit
With respect, my lady, I would accept that the third limb is something, first, that this court should consider, and secondly, which is completely consonant with modern policy, is also not very far from Mr. Sumption, as he then was, fourth test of you look at it in the context of the policy in the area. And so I don't need to go that far for the purposes of this appeal.
Thank you.
But I would certainly accept that there's much wisdom in the third stage.
A residual discretion at the end of it all?
Yes, a standing back.
No, it wasn't what I was meaning. I was
Forgive me.
meaning the interdependence point. Was I?
Well, yes. I mean, perhaps I confused two issues there. But I accept my lady's point that there's much force. And one of the reasons I say a standing back is that the third limb in Atwood is described in different ways in different cases. Yes. I certainly accept my Lady Arden's point as to the correct description of it. It is also described in the Beckett case, I think, as a sort of discretion. And there's definitely a consideration there. Can I deal with that when I get to Beckett, my lord? Only because we have some way to travel and I'm conscious of the time. Scully was the next case I wanted to look at. I won't look at all of the Court of Appeal authorities. You'll see in our printed case, we say there were 6 and they all speak with one voice. But Scully is at 1285, or in the hard copies at A2. Give me while I turn mine up. 22. And we've already looked at this, obviously, earlier this morning. Can I just go straight then to paragraph 31, which is at page 1290. And it's behind, I'm so sorry, my lord, it's behind tab 20 in volume 2, to the extent that you need it in the hard copy. And so what they say at paragraph 31, severance of part of a covenant is only permissible in cases where the obligation to be severed is truly a separate obligation to that to be enforced. If obligations are in any way interdependent as a matter of wording or meaning, then severance will not be permitted. And then they go back to the words of Lord Moulton in Mason. And then they say, paragraph 32, that statement by Lord Moulton was considered by the Court of Appeal in T. Lucas, which we've just looked at, obviously, considered and applied. And then just looking a little bit further down, because it's a way of picking up yet another Court of Appeal case without dealing with it directly, the end of that paragraph, you'll see, thus, as stated by Lord Justice Glidewell in the Rex Stewart Jeffreys Parker Ginsburg case, a contract can be severed if the severed parts are independent of one another and can be severed without severance affecting the meaning of the part remaining. So this is absolutely a tried and tested test. It has persisted and been applied repeatedly by the Court of Appeal over 100 years. None of these judges, I hear what's said at first instance, but none of these judges think there is some difficulty with the test, precisely because, we would say, they well understand that if you haven't got separate obligations, you just don't get to severance. And then we get to, sorry to take it so quickly, but then we get to Beckett, which is at 816. And in the hard copies, my lord, that's file 1, A1, tab 3. Now, Beckett, of course, we have looked at. The backcloth to Beckett is that you have half a dozen Court of Appeal authorities all saying separate obligation. Now, plainly, if the Court of Appeal were going to depart and say that those cases were wrongly decided, it would say so somewhere. Interestingly, when we look at it, we'll see not only does the Court of Appeal not say that those cases were wrongly decided or the test should be abandoned, it expressly says that it is following Atwood. And if I can pick it up at paragraph 33, so 33, the final controversy is severance. Judge thought it wasn't severable. And then turning to 35, 34, he considers what Lord Moulton said. And he says this at 35, to the extent that Lord Moulton was suggesting there's a special rule referable to employment contracts, his observation has not found favour in more recent authorities, see T. Lucas, Stenhouse. Like the judge in the present case, I find the appropriate starting point to be Atwood and Lamont. So, pausing for a moment, what he's saying there about what Lord Moulton has said is only in relation to the triviality point, namely the requirement that you can only have severance if you've got separate clauses and it's trivial. And again, triviality is not something which I need to urge on the court. I don't obviously resist the court considering it. And then we get to the approach to Atwood. He cites first Lord Sterndale, Master of the Rolls in Atwood. I think, therefore, that it is still the law that a contract can be severed if the severed parts are independent of one another and can be severed without the severance affecting the meaning of the part remaining. He considered severance was applicable where two parts of the covenant are expressed in such a way as to amount to a clear severance by the parties themselves and as to be substantially equivalent to two separate covenants. Now, this is what the Master of the Rolls was saying in Atwood, as I say, entirely consonant with the other two judges. 37, Lord Justice Younger put it this way, and you'll forgive me for not rereading it, you've looked at it before. And then at 38, although strictly obiter, those statements have always loomed large in any consideration of severance. It's obviously right, because we've looked at a large number of Court of Appeal authorities where those statements have been repeated and followed and applied. There's only one aspect of Atwood which has been authoritatively rejected. That was the suggestion that in employment cases, even where the prerequisite, and I would underscore the word prerequisite there, the judge plainly understands that there was a prerequisite of several clauses is established, the court may nevertheless decline as a matter of discretion to order it. And can I pause there? That's the tension I was drawing attention to between what I think my lord asked me and what my lady asked me. Here, Beckett seems to look at it as a sort of standing back discretionary stage at the end of it all. That's broadly what seems to be being said here. But we just pause because to the extent that one says, well, has the test worked? We know that we've had, at this point, the test of separate obligations for more than 100 years. And in more than 100 years, that test has not been doubted. That is a powerful test of the rule. It has not been doubted. Now, what is said is that this case puts that rule on one side. As one sees, that just becomes impossible as one reads on, because one gets to paragraph 39. As I read that later judgment of the Court of Appeal, namely the Court of Appeal in Lucas, it expressly adopted the thrust of Atwood. The thrust of Atwood is separate obligations, but simply rejected the discretionary element, as we've just been discussing. 40, in a number of more recent first instance decisions, and then they go through the first instance decisions, and can I come back to those, because I'm going to deal with those specifically. But having looked at those first instance decisions, namely Sadler, he says this, he rejects at the foot of page 828, Mr. Oldham seeks to question these decisions on the basis they're either an aberrant extension of Atwood or that they apply only within a subset, the distinguishing characteristic of which is that they involve the future payment of money on a terminated contract. In my judgment, these more recent cases are neither aberrant nor merely applicable within a subset. In T. Lucas, Lord Justice Russell referred to the necessary approach being as a matter of construction, including the question of whether the one obligation can be removed, severed without altering the nature of the contract, etc., etc. So all that is being said is that the Court of Appeal didn't consider there to be a difference between the Sadler test and the separate obligations test. Nowhere in this judgment do we see their lordship saying, well, we've considered Lucas, Rex, Atwood, they're wrong. Very experienced Court of Appeal, if they thought that they were overturning 100 years of case law, they would say so with greatest of respect. What they think is that it's the same test. And so what's very instructive is, whereas I submit that Sadler can be treated as the same test, provided you understand that separate obligations is part of it, Mr. Laddie submits that, in fact, a new test came into being here. And that it's an easy-to-surmount test. Somehow there was some lowering of the threshold, and we say that's completely wrong. Beckett will not bear that weight. It follows Atwood. It's the sixth in a long line of Court of Appeal authority. So can I turn now to why I say that sometimes figurative language, if I can put it like that, in Sadler and Marshall might lead to confusion, and why those are different cases. That's not to say that they are aberrant, it's to say that the court is doing different sorts of work in those cases. If I turn up Sadler, please, which is at page 1266, that I think will be volume 2 of the authorities. So in the hard copy, it's behind tab 20. Oh, I'm sorry, I think I've given the wrong page reference. Just bear with me, my lord. Sorry? I'm so grateful. 1264, as my lady says. Can I just explain what's going on in this case by reference to 1266? Just to give you, if I may, your bearings. I appreciate you will have looked at it. And the paragraphs we really need to look at are paragraphs 4 and paragraph 9. So at paragraph 4, we see that we're concerned with what's described as subclause 5A Roman 6. And if we just break that down, at A, there is broadly an obligation to pay commission. So that's A's obligation to pay, the employer's obligation to pay. And then at B, there are provisos to that obligation to pay. And there are two provisos if you look at B. The first is to do with 10th anniversary, etc., etc. And then the second is provided that the agent's entitlement to such commission will immediately cease if they enter into a contract of service. And so what one has here is, and one sees this at paragraph 9, it has been agreed by the parties that if the proviso on its true construction operates as a restraint of trade, it cannot be justified on the ground of reasonableness. The question of reasonableness has not been argued. The formal issues before the court, as extended and defined by the agreement at the trial, are therefore, 1, whether the proviso to the clause is void, and if the answer be yes, whether the whole of that clause is to be struck out or only the proviso. So the question in that case is, if I strike out the employee's restraint, does the employer's obligation to pay stand? Now, one can see immediately what's interesting about the case. On the court's analysis, these are really separate obligations. It's the employee's obligation to stay or to be restrained. It's the employer's obligation to pay. But it seems a bit odd if you're taking out the employee's obligation to then enforce the employers. And so that's why we see the formulation at 17 onwards. And if we just pick it up at 17, the first point to make, insofar as it said that there was some change in the law, even in Sadler, we respectfully say that Mr. Crawford QC, sitting as a deputy, was not purporting to change the law. On the contrary, at paragraph 17, he cites Lucas and Mitchell in the middle of paragraph 17, and the passage he cites in the middle of it provides, amongst other things, in our judgment, clause 16 is properly to be regarded as not merely a single obligation not to deal, solicit or supply, but as two separate obligations. So he has well in mind the separate obligations test. Then at paragraph 18, he cites the Comidas case, and one will note immediately what Lord Justice Buckley said in that case is, I doubt whether this is really a question of severance, in the sense that it's a rather different case. But then at 19, he says this, in my judgment, the combined effect of those authorities, just pausing for a moment, he is not, with greatest respect to him, purporting to change the law at all. He's stating the combined effect of the authorities.
You can't change the law.
With respect, my lord, no.
No.
But what I'm really saying is, nor was he purporting to. It's a perfectly sensible thing to say, that he's trying to reach for the combined effect of the authorities. But what's interesting is what follows. He says, the combined effect of those authorities is that a contract which contains the unenforceable provision nevertheless remains effective after the removal or severance of that provision, if the following conditions are satisfied. He's not actually asking himself the severance question there. He's saying, I've severed this bit, what do I do with the rest of it? And with the greatest respect to the judge, it's a perfectly sensible question to ask, because you can see immediately that the problem that the Sadler case throws up is the odd one of removing one party's obligations under the doctrine of restraint of trade, and then the other party being asked to perform its obligations. And one also can immediately see that when you're asking that question, one thinks, well, is that the sort of contract the parties entered into? So you can see why the deputy judge asked himself that question in this case. And of course, very strikingly,
Well, that's why he's asking the question about consideration, isn't it?
with
Because
respect,
otherwise, that question doesn't really make much sense.
with respect, my lady, yes. And one has to see it through those eyes. You see, it's not that he says there doesn't need to be severable obligations. There are in this case. That's not the interesting thing to discuss. What he's focusing on, the real issue in that case, what he's trying to grapple with, is rather different. And one sees that again, if I may, in the next case of Marshall. So that is 1025, or in the hard copy, it's file 1 of the authorities at tab 12. Just give me a moment to turn that up myself. Now, in some ways, Marshall is an even more interesting case, because in Marshall, there are two aspects to the severance. And again, can I just do this by reference to the clause? I know it seems slightly strange to start with the clause, but if I may. So at page 1028, you have got the clause at C. And again, a little bit like the clause we looked at earlier, under clause 10D, you effectively have payment clauses. So one finds payment at G if at the date of the termination of this agreement, the agent has, for a period of not less than 5 years, been continuously an agent of the company, and either Roman 1 hasn't competed, or 2, Roman 2, has reached 65, then the company shall pay the agent renewal commission. So again, it's that classic payment obligation restraint, but this one has quite an interesting twist. So at C, at page 1029, he says this: I do not think there can be any doubt that Proviso Roman 1 is a restraint of trade. Proviso Roman 1 is a financial incentive to the agent not to carry on business, etc., etc. And then at H on the same page, the more difficult question and the real bone of contention in this case is what follows from the unlawfulness of Proviso 1. No one contends the entire contract is void. The question is how much is to be removed. If the whole of 10G is struck out, then the plaintiff will not be entitled to renewal commission, because that clause is the same, is the sole contractual basis. If Proviso 1 alone is struck out, the plaintiff will not be entitled to renewal commission, because his right will continue to be dependent on Proviso 2, that he should have attained 65 years. He's only 40. The only modification of this agreement which will enable him to receive the renewal commission is the excision of Proviso 2 as well as Proviso 1. So this is why I say it's Sadler with a twist, because he carries out severance twice. And so the first question he asks himself, and if I could just ask you just to look at 1030, the first question he asks himself is whether Proviso 1 and Proviso 2 are severable. Because the question he's asking himself there is whether the obligations, effectively, of the employee, one is restraint of trade, one is reaching a certain age, whether those are one condition. And what he says is Proviso 1 can never have been intended to operate independently of, Proviso 2 can never have been intended to operate independently of Proviso 1. I'm looking at 1030H. And then at the end of that, Proviso 2 is in reality a proviso to Proviso 1. If it were expressed like that, it would certainly fall to be struck out if Proviso 1 was struck out. Does it make any difference that typographically the clause has been arranged as if these were two independently operating provisions? In my judgment, it does not. And he talks about looking at the substance, and that's all common ground. And then at C, he says, it would be wrong for me to strike out Proviso 1 alone, for that would radically distort the effect of 10G. However, it's open for me to strike out both provisos on the ground that they are inseparable parts of a provision directed to the restraint of trade. So, just pausing for a moment, and that is the interesting point in the case. If you look back at 1028, when he asks himself the question, I know this becomes terribly convoluted, I'm sorry, in relation to G Roman 1 and Roman 2, is Roman 1 severable from Roman 2? He says, are they separate provisions? Because there he's dealing with something which is akin to a restraint of trade. The other point to take from this judgment of Mr. Sumption QC, as he then was, is that he has no difficulty in saying that both of those provisions are inseparable parts of a provision directed to the restraint of trade. That is notwithstanding that the second part of those provisions has nothing to do with the restraint of trade at all, but they're all part of one integral clause. He doesn't say, well, I look at the age clause and I treat that as not caught by the restraint of trade doctrine. Of course not. They're all part of one clause directed to the restraint of trade. So again, on the point that we touched on yesterday, restraint of trade itself, this authority supports our approach. So the question he then has to ask himself is, having struck out the obligations on the employee, the obligation 1 to reach a certain age, and the obligation 2 not to compete, put in very simplistic terms, he asks himself the question, well, should I still be enforcing the employer's obligation? And that's where at page 1031, 1031E, he says this: since the excision of those two provisos can be achieved without injuring the grammatical sense of what is left and without leaving a contract unsupported by adequate consideration, I pause there to note echoes of my Lady Hale's point. The choice between these two alternatives depends upon the excision of both, whether the excision of both provisos alters the character of the contract. And this is why we end back in Sadler. And what he says is this is an easier test to formulate than to answer. And then he applies, I won't go through it, the Sadler test, which is obviously overleaf at, earlier at 10:30. So, very important to understand what's happening in the Marshall and Sadler cases. Completely understandable that the judges in those circumstances stated the test in the way that they did. But one only has to look at what the Court of Appeal said. If one just looks at very, very quickly at Marshall in the Court of Appeal, and I don't think most of these points weren't an issue on the Court of Appeal, but if one, it's electronically, I think it's at 1837, and it will be in the hard copy documents at tab 57, which is in Authorities Volume 4.
Sorry, electronic.
I'm so sorry. It begins at 1837.
Thanks.
And I'll just pick it up in the judgment, just so we can see what's going on, I think, at page 1840. What's said is this. The defendant appeals from this last ruling and submits the whole of Clause 10G should be struck out, leaving the plaintiff with no entitlement to post-termination renewal commission. So the appeal is really about, if you're going to strike out Roman 1, Roman 2, you've really got to lose the whole of 10G. You can't still enforce the employer's promise. And what Lord Justice Millett says at page 1841, letter D, although the question is described as severance, it is important to bear in mind that we are not concerned to decide how much of an offending restriction should be struck down. In such a case, the question is to what extent can the party who imposed the restriction enforce those parts of it which are not in unreasonable restraint of trade. We are concerned with a very different question, namely whether the party who has been freed from an invalid restraint of trade can enforce the remainder of the contract without it. And so, to the extent that the Court of Appeal has engaged with Marshall and Sadler, Lord Justice Millett plainly understands, and we would very respectfully submit, is plainly right to say that it is a very different question. And we say that to the extent that one does see any recent confusion, the confusion comes not from the separate obligations test, but from importing a test which is obviously designed to deal with something rather different, which is fine, provided one remembers the separate obligations, which obviously the Court of Appeal had in mind, but perhaps it's not as clear as it might be. So that is what I say as to severance. Can I move on now to practice and how it works in practice? And as I say, very, very heavy reliance placed on first instance authorities. But what we say is this: the approach in this area must be driven by principle. It always has been driven by principle. And if it were right, I don't accept it, but to the extent that there is any confusion in the first instance decisions, that only underscores the importance of restating principle. It's not a reason for departing from it. And we say, with the greatest respect, in the Fresh Asia case, for example, far from a guide to the correct approach, it actually demonstrates some of the difficulties. I mean, it's actually instructive in that case to compare, for example, and I'm not going to do this exercise if you'll forgive me, but if one compares paragraph 1, the injunction granted in that case, with paragraph 63, and I'm sorry, I don't have the copy with the electronic numbers on it. This is the Fresh Asia case that was obviously handed up, and so I'm sorry not to go to it, but what I'll just say, and I'm not going to press this exercise on you now, is if you compare, as I say, paragraph 1 of that case with the clause itself, what you will see is impermissible judicial rewriting. I don't say that by way of criticism with respect to the judge, but it's the difficulty one falls into if one abandons the requirement for separate obligations. The only other point I would make in relation to that case is, as the deputy judge said at paragraph 104, the mischief to which the House of Lords in Mason referred should be addressed in some way. He said overbroad and uncertain restrictions are legal litter which cast an unfair burden on others to clear them up. And he thought there should be a consequence for those responsible, and questioned whether in some cases relief might be refused.
Which paragraph was that?
That was paragraph 104 of the judgment.
Yeah.
Let me just... I don't accept there's a long list of things that one could say are wrong, with greatest respect, with the Fresh Asia case, but to the extent that it's an illustration of what can go wrong, it's an illustration of the difficulty one gets if you have this submission that somehow Beckett abandoned 100 years of case law. Once one comes back to principle, you can have a principled approach, as I say, and ultimately, with severance, as the court said in Mason, if it's not clearly severable, it's not severable. So that's what we say as to practice. Can I turn finally, in the few moments left to me, to my sixth proposition, which is that the appellant's contention that the Commonwealth authorities support a watering down of the test is wrong. We just take you, if I may, to the decision of the Supreme Court in the Chaffron case. There's a real oddity about the way the appellant puts its case, because it puts its case by reference to a Singapore case, which I'm not going to turn up. The Singapore case, with respect, misstates English law. It assumes that Atwood has been overruled. It also misstates Canadian law. So it really takes one nowhere. And but again, it's the reverse of a principled approach. One cannot start with the first instance decisions, see if one can discern something, and then reverse engineer long-standing principle. One starts with the principle. Now, if one just turns up then the Chaffron case, which is at page 2402, please, electronically, or file 6 of the authorities at tab 85. And so, just picking it up in the head note, it was a sale of an insurance agency, and then he's employed, and there were employment contracts, and each of the employment contracts, one sees, and I'm looking at page 2402, each of the employment contracts, he agrees that for 3 years after leaving his employment, he won't be employed in the insurance business. And then if we just pick up the policy points and the Atwood points, if I may. First, as regards the Canadian approach to sale of business versus employment, one finds that at page 2412, please, paragraph 21. Again, if I may say, it echoes the point made by my lady, Lady Arden. The sale of a business often involves payment to the vendor for goodwill. In consideration, the goodwill payment and the custom of the business being sold intended to remain and reside with the purchaser, as Lord Ashbourne observed in Nordenfelt, and then sets out the classic English statement of principle, if I may say. And then one sees at 22, the same considerations will not apply in the employer-employee context. No doubt, an employee may build up a relationship with customers, but there is normally no payment for goodwill upon the employee leaving the employment of the employer. It's also generally accepted that there's generally imbalance in the power between employee and employer, and that may provide a far more eloquent answer than I was able to provide to my Lord Briggs.
Well, she concentrates on the payment point.
With respect, yes.
Yeah.
Yes, and that, as I say, is a better summary of the mine of my understanding of the essence of the principle. And so then, what one comes to severance itself. And so this, I just pause for a moment. This is the decision in 2009, so it postdates Beckett. And what's said at 29 is blue pencil severance was described in Atwood and Lamont.
For 229.
Oh, sorry, did I say 229? I meant paragraph 29, page 2415.
Thank you.
I'm so sorry, my lord.
Yeah.
And as follows, and then if I can just pick it up further at 32, must be recognised, however, the court altering the terms of the original contract. Courts will be restrained in the application of severance because of the right of the parties freely to contract and to choose the words that determine their obligations and rights. And then over leaf at 33 onwards, one sees how severance applies to restrictive covenants. And at paragraph 33, there's reference again to Lord Moulton's well-known statement.
Only part of it.
Yes. Although, if I may say, well, in fact, I say only part of it. It's interesting, my lady. If one looks at 34, one sees. I think my lady asked me the question. You know, what's wrong with almost this third stage? Do you also need it to be not just severable, but also trivial? And that doesn't appear, as I read this case, in fact, to be rejected by the Canadian courts. And if one just, yes, I mean, one really sees that at 33 and 34, and if one just looks at 36, I think the approach of Lord Moulton in Mason is the appropriate view of the law, rather than the approach taken in cases cited at paragraph 35 above. I'm of the opinion that blue pencil severance may be resorted to sparingly, and only in cases where the part being removed is clearly severable, trivial, and not part of the main purport of the restrictive covenant. However, the general rule must be that a restrictive covenant in an employment contract found to be ambiguous or unreasonable in its terms will be void and unenforceable. So the Canadian cases go further. They effectively have this additional limb of it needing to be trivial. The notion, as the appellant would have it, that the Commonwealth cases support a watering down of Atwood is plainly wrong.
You're running out of time, so you haven't got time to go to paragraph 49. But privately, we will do so and ask ourselves whether there has been a different test in Canada articulated by Lambert, J.A.
Yes, when you read this authority, can I also say that one has to have in mind the two types of severance, blue pencil severance and notional. I know you have this in mind, of course. With
Notional severance, as I understand it, is a sort of construction point, isn't it?
Yes.
Yeah.
Yes,
Well, we've gone beyond that for the purposes of this argument.
Yes, exactly.
Yes.
It's an instructive case, but the two things one can take from it are, one, Canadian law, in fact, on this decision of the Supreme Court, goes further than English law, in that it endorses the full scope of Lord Bolton's observations. And we do say, but obviously be open to this court to do so, for all of the policy reasons that are outlined in Chaffron and the other cases. I don't need, as I say, to go that far, but this court could. And secondly, we say that the reliance on a first instance Singaporean authority to say that Canadian law says something else just takes one nowhere, but it rather illustrates the difficulty with trying to build things from the ground up. One has to start with the principle. I don't say, for the avoidance of doubt, noting that very little time is left, I don't say that the Commonwealth speaks with one voice. If one travels the globe, one sees different approaches. And so, for example, I think we've given you one Australian case. In Australia, you have, in some states, you have broadly Atwood, but then in New South Wales, you have statutory rewriting. In New Zealand, you have statutory rewriting. If one were to look at the position in the US, it ranges from states which take a fairly English view, say Massachusetts, through to California, where you can't enforce. So one doesn't see a uniform voice across the globe, but to the extent that one sees English law being applied, and Canada is, as I say, a very good example, there's really no difficulty with Atwood. And again, nor is there any suggestion in Chaffron that somehow the separate obligations test is proving impossible. It's not. And so, to conclude, we say that this case, this appeal, provides a modern illustration of the mischiefs identified by the House of Lords in the Mason case, and in particular by Lord Morton. Those words are just as powerful today as they were when spoken 100 years ago. Where an employer exacts a covenant framed in unreasonably wide terms, the courts will not and should not come to the employer's assistance by applying their ingenuity to carve out a valid clause. Secondly, we say the real sanction on the back of these covenants remains the terror and expense of litigation, which in many, many cases will favour the employer's deeper pockets. And thirdly, we say the hardship imposed by unreasonable covenants would be greatly increased if employers are encouraged to draft them in the widest terms in the expectation that, having exposed the servant to the anxiety and expense of litigation, the court would in the end enable them to obtain everything they could have obtained by acting reasonably. So we say, as a matter of law and as a matter of policy, this appeal should be dismissed. My lady, those are my submissions on behalf of the respondent, unless you had anything further for me.
No, thank you very much indeed, Mr. Woodkirk. Ms. Rogers? Mr. Leddy.
My lady, I'm going to start my reply by focusing on my learned friend's case on severance. His principal submission was that there has been no real attempt to doubt 100 years of authority encapsulated in the separate promises test. But when pressed to explain how the separate promises test operates in practice, in my submission, my learned friend's arguments fell apart. He resorted, in my submission, to the question-begging theory of separate concepts. He explained the principle behind the alleged distinction between a non-dealing clause and a non-solicitation clause as being founded on them being separate concepts, notwithstanding that both could readily be combined in a clause which said, you shall have nothing to do with any of our customers. But what about this case, the case of Egon, Zehnder and Tillman, given the objectionable element of the clause in issue? That clause is a non-competition clause. It is made against the backdrop of an employment relationship as between Mrs. Tillman and Egon Zehnder, an employment relationship under which Mrs. Tillman provided her services. She exercised her labour on behalf of Egon Zehnder. Why is it not permissible to recognise as a distinct concept, on the one hand, a non-competition clause preventing labour, in other words, preventing Mrs. Tillman from working in a rival concern, and as a separate concept, her having an equitable stake in a rival concern? All the more so, since it is only the former that she was employed to do. She only ever worked for Egon Zehnder. She never owned shares for Egon Zehnder or in Egon Zehnder. I will show, I hope, shortly how the analysis being undertaken by my learned friend is inconsistent with the authorities. But can I first of all deal with a separate point, a question that he posed, which is that there would be a difficulty for first instance judges having to address the three-limb Sadler test in practice. In fact, all that one needs to do is to apply the principles expressed in Atwood over the course of the last 100 years. In fact, the cases cited by us at paragraph 66C of our printed case, supplemented since by Fresh Asia and at least one other decision in the High Court, demonstrate that the courts at first instance have no difficulty whatsoever applying the Sadler test. And to the extent that they cite Atwood, they, just as the Court of Appeal in Beckett, effectively pay lip service to it. The language of separate promises is simply not apposite in these cases, and one finds that it is simply not used any longer. It does not cause practical difficulties. But in any event, the suggestion being advanced on behalf of the respondent that there is some ready reckoner in terms of being able to identify separate promises is simply without foundation. I'll turn briefly, just give you some references to some of the cases that he referred to. British Reinforced Concrete and Shelf, page 838. That's tab 4 for my Lord Wilson, page 838. It will be recalled, I'm not going to read it out, that Lord Justice Younger in that case, having relied on the expression of principle in the divisional court, not the Court of Appeal in Atwood, refused to sever part of the clause, but said that he would sever out the words or manufacture. The original prohibition was against sale or manufacture of road reinforcements. And the purchasing company, of course, engaged in both. what is the conceptual philosophy underpinning Lord Justice Younger's readiness to sever manufacture but not sale in that case? It is elusive, we say, to say the least.
Is it made any clearer if one realises it's an inverse proposition to interdependence?
The problem with these kind of tests is that it is very easy for two different courts to take a different view as to whether something is dependent or interdependent. And can I illustrate this by reference to Lucas? And I accept that Lucas, the criticisms of Atwood in Lucas are limited. I think it's, just give me the page reference, it's 11. Tab 11. Sorry, I've got the wrong reference, I beg your pardon. Tab 10. Page 1006, thank you. One of the matters that was explored by Lord Justice Russell in Lucas was the question of separate promises. Can I take the court, please, to page 1013? At just above F, referring to the language of Lord Justices Atkin and Younger, and indeed Lords, to a certain extent, Sterndale. The sentence beginning, but their whole approach, based on policy and the undesirability of permitting a system by which an employer might cow an employee into submission to unenforceable restraints, and at the same time, if accused of too wide a claim, successfully assert a narrower, would, it seems to me, be equally applicable to a case in which two restraints were indubitably separate and distinct, being, for example, in two different clauses. And that's a critical point, we say. There is a recognition here of the formalistic nature of the Atwood test. That if the covenant is capable of being divided as a matter of language into separate clauses, as ours is, we could readily divide out interested into a separate clause, then it becomes, in the language of Lord Justice Russell, indubitably separate and distinct. But we don't need to just rely on Lucas. We rely, of course, on Beckett. And I know that I took the court to Beckett in my opening submissions, and Mr. Aldkirk has done so in reply. But I note this. Mr. Aldkirk's reading of Beckett stopped at paragraph 42. That's page 829. Now, by this stage, of course, by the time we get to the end of paragraph 42, the Court of Appeal has already cited Sadler and Marshall, and of course it's in Marshall at first instance that Mr. Sumption made that observation, again not addressed by my learned friend, about the test in Sadler being altogether more satisfactory than the traditional and question-begging test identified in Atwood. So that's where we've got to up to paragraph 42. There's then the citation from particular words from Lord Justice Russell. As a matter of construction, including the question whether one obligation can be removed or severed without altering the nature of the contract, it is that citation, that limited citation, as we can see from paragraph 43, which he regards as being without any difference from the words in the threefold test propounded in Sadler. There is a departure here from the separate promises test. And that is why they go on to provide the guidance that we see at the end of paragraph 43. Guidance which on its face makes no mention of separate promises. But if there was any doubt about it, it is resolved in our submission by the result of what happened in Beckett. What happened in Beckett was that a part of the definition of relevant client was severed. How does that work on my learned friend Mr. Alkirk's separate concepts test? Now, we have, we say, got to recognise the difficulties for the Court of Appeal in formally overruling a set of principles which, at least in form, have stood for a long period of time. But better, we submit, to recognise what is happening in reality, to recognise that the test in Atwood is incapable of coherent or sensible application, and that the test which was initially developed, admittedly in different circumstances in Sadler and Marshall, is a more appropriate one for dealing with the question of severance in this day and age. It isn't a difficult proposition, and we know that because it's what High Court judges are doing when they are being confronted with this sort of issue. I'm just going to leave that. The final point, criticism was made on of Fresh Asia. Can I know that Mr. Alkirk said somewhat tantalisingly that there were lots of criticisms that had been made of it before declining to identify even one. But can I, just for the Court's note, I directed the attention of the Court to various paragraphs yesterday. Can I also indicate paragraph 52? It might be helpful. Again, I'm sorry, I don't have the electronic reference, if indeed there is one.
There is.
It might be sensible to take this just from the end of paragraph 51. As Lord Justice Russell noted in Lucas, that's the indented words in Beckett. Mr. Alexander QC goes on to say this. That point, I'm not going to read it out. Can I just invite the Court, please, to read paragraph 52, where Mr. Alexander QC concludes that trying to analyse a covenant to see whether it contains separate clauses or not gives rise to the scope for this sort of argument to descend into debate over whether a formally unitary provision containing words or punctuation of disjunctive connotation should be regarded as separate or single in nature. Employers and employees are likely to view this with dismay as costs rack up over commas. And that is why the Sadler test is better rather than the, in our submission, ultimately incoherent and circular test in Atwood and Lamont should be preferred. Can I, in the very brief time left to me, just deal with points arising under grounds 1 and 2? Can I just deal with two essentially housekeeping points first? First of all, my Lord Wilson asked yesterday whether the reference in Chitty in the Court of Appeal was the same, notwithstanding the development in the additions. The wording is identical, word for word.
So, I know you're short of time. What is the reference in the new edition of Chitty, which is equivalent to Lord Justice Longmore's reference?
Mr. Solomon will come to my
Otherwise, we can't make any sense of your point.
Mr. Solomon will come to my aid to give
Very
you,
well.
give you the...
Yes, very well.
Second, the model clauses point. The two leading textbooks in this area, to the extent this is of significance, are Brearley and Block and Goulding. And Goulding hadn't been published by 2004, and Brearley and Block, which had been published by 2004, didn't contain any model clauses. They came in 2009. Cameling, as my learned friend has shown, did have model clauses. It is a little-known textbook. That's not in any sense to denigrate the quality of its contents. It is. It has only, as far as our research has shown, been cited in the courts on two occasions, 2012 and 2017, and only in 2017 in an employment context. On ground 1, yesterday, my Lord Wilson put forward to my learned friend the proposition that there must be some limitation to the application of the doctrine, and invited my learned friend to put forward his case as to where the limits might lie. My learned friend appeared to accept that there must be some limits to the doctrine, but declined the invitation, for good reasons, so it appeared at the time. But he then went on to say that in any case of an employment contract which contained post-termination restraints, he said it would always attract the doctrine of restraint of trade. That was his third proposition yesterday afternoon. That, in my submission, involves the triumph of form over substance, because on his case, it doesn't matter what the nature of the restraint is. He is cutting out the possibility of the courts examining for themselves whether or not, in truth, this is a restraint of trade within the parameters of the doctrine. He also raised the suggestion that if this was to be an issue before the courts, it might cause practical difficulties for judges. But as this case demonstrates, the practical difficulties can be overstated. Applications for injunctive relief require or generally involve both parties producing witness statements, typically dealing in most of these cases with reasonableness. There's no reason at all why they shouldn't deal with points of fact going to the application of the doctrine of the restraint of trade. It isn't a significant additional hurdle or task for the court. Finally, can I deal with just a couple of points on construction? First of all, an observation that at no point during the course of his submissions under our ground 2 did my learned friend actually go or perform the sort of textual analysis that we performed, that Mr. Justice Mann performed, but which the Court of Appeal did not. Ultimately, despite disavowing that this was what he was doing, he did indeed seem to rest his case on the principle that interested in always captures as shareholding. Can I just give a couple of references to some cases which to some cases to which he referred? First of all, Smith and Hancock. That was the T.P. Hancock case. Can I, although my learned friend referred to the two judgments in the majority, he didn't refer to the dissenting judgment of Lord Justice Kay at page 1280. Lord Justice Kay, I appreciate he was in the minority, but he held that interested in connoted active interest. And that's page 1280, it's tab 21 for my Lord Wilson. Although he said that Gambaroni could be dismissed on the grounds that it's a first instance decision, that didn't stop him, of course, from referring to the first instance decision of Mr. Justice Silber. We would submit in CEF, we would submit that the decision of Mr. Justice Foskett in Gambaroni is the more valuable analysis for two reasons. First, it was reached after a trial rather than merely a return date on an application for injunctive relief. But second, it is the only one of the cases which involves circumstances which, to put it neutrally, involves a case similar to ours. That is to say, first of all, a live issue as to whether interested in captured shareholding, not a live issue in any other case, and second, the presence elsewhere in the contract of a clause making express reference to shareholding. What those authorities demonstrate is that there is genuine ambiguity. One could end up, no doubt, in an endless academic debate about what precisely that may mean in a particular situation. Whatever it does mean, we say that we have it in this case. It satisfied Mr. Justice Foskett, and it satisfied Mr. Justice Mann. And we say that it isn't accidental that they are the two judges that have reached that conclusion favourable to the appellant's case, having conducted the textual exercise which has so conspicuously not been undertaken by the Court of Appeal and Mr. Alcock. And finally, two points. First of all, grateful to Mr. Solomon for coming to my rescue on the Chitty reference, my lord. It's 16-215.
Thank you.
That's the 32nd edition. The 33rd edition is
Yes.
critical. That's the reference to where it is in the London.
And the second point is I said that Mrs. Tillman didn't hold shares in Egon Zehnder. She did hold shares in Egon Zehnder. And if my lord wants the reference to the 33rd edition of Chitty, it's tab 27, page 135.
You say Longmore LJ's reference is equivalent to 16215. That's the end of it.
6240.
Thank you. And, sorry, forgive me, I'm sorry, now I read my learned friend's notes properly. It's 16240, I think.
Oh,
But it is still identical.
very well.
That we have checked. 240, but we have checked it. Thank you, I have no further submissions.
You say she did hold shares. Was she required to hold shares?
Yes,
She was required to.
So she was, but when she became a partner much later.
Oh.
She wasn't a partner at the outset of the employment relationship. This is an oddity. There's an oddity about this case. Mrs. Tillman remained an employee throughout her tenure at Egon Zehnder, but after several years she became a partner, as one would have seen from the judgment of Mr. Justice Mann. It was at that point.
Very well.
The point I was making was that shareholding is not part of their business. There was nothing to add.
Nothing to add.
You were looking expectantly, but there was...
Well, I wasn't sure whether there was anything to add, because you were looking quite expectant too. But by the clock on my machine, you're exactly on time. So many congratulations to everybody. And many thanks for your very interesting arguments. And we will now go away and see what we make of them, and let you know in the usual way in due course. Court will now adjourn.